Hello to all, and welcome to today's webinar, Investment Arbitration in Latin America, Current Challenges in an Unstable Region. This is an event organized by Colombia International Arbitration Association with the support of Arbitration Channel. My name is Gino Rivas, and along with Elora Farias, both LLM candidates at Columbia Law School, we will be moderating this event. Thanks to all for coming. We're very glad to have you here, and thanks especially to our amazing speakers who will be presented very soon. This webinar is inspired by the current situation of Latin America. Certain countries such as Bolivia and Venezuela have denounced the ICSID Convention. And furthermore, the current political situation in the region may result in a continuing trend against ICSID. For example, in Peru, there are already some voices from certain political parties that call for leaving the convention. Regarding the denunciation of the ICSID Convention, or of other investment treaties, there are three topics that arise and will be addressed today. First, sunset clauses, as they extend the effects of treaty provisions. Second, UNCITRAL arbitration as an alternative, because even if a country withdraws from the ICSID Convention, investment treaties may still provide for UNCITRAL arbitration. And third, treaty shopping, as some investors may try to remain protected by other investment treaties. Now, Elora will present the speakers of this webinar.
Thank you, Gino. And once again, on behalf of the SAIA, we thank the speakers and Arbitration Channel for being a partner of us in broadcasting these events. Well, our speakers have been awarded so many times that I'll try to be brief, but at the same time, make well of them. The first one, Jennifer, is a partner at Sidley Austin and serves as counsel in complex international arbitration cases with a focus on investment treaty arbitration. She's consistently recognized for her arbitration work and ranked in 2021 in the edition of Chambers Global, as well as the 2020 and 2021 edition of Chamber USA in International Arbitration. Patrick, a partner at Debevoise, in the International Dispute Resolution Group, focuses on commercial and investment treaty arbitration with particular experience in the upstream oil and gas, energy, and telecommunications sectors and tax-related disputes. He's also recommended as a leading lawyer for arbitration in Chambers Global 2001 and Chambers UK 2022. And last but not least, Roberto, who is a partner at King & Spalding, specialized in counseling multinational corporations and complex arbitration, listed as leading member of the International Arbitration Bar in the 2011 Global Arbitration Review 45 under 45 rankings. Roberto has also been individually recognized by Chambers Latin America and featured in Who's Who's in International Arbitration. The floor is of the speakers.
Well, thank you. I believe that I'm going first, and I wanted to first thank Colombia International Arbitration Association and the organizers of this event, Gino Rivas and Elora Farias, for inviting me to participate on this panel on this very interesting topic. And for my part, I'm going to be discussing, broadly speaking, kind of the denunciations with respect to ICSID Convention in particular, and terminations of unilateral terminations of bilateral investment treaties and the implications for that. And then also with respect to, as Gino had indicated at the very beginning, with respect to the what I'll call survival clauses and what the implications are for those who are investors in using these arbitrations and these treaties. So anyway, speaking first, I wanted to kind of note that clearly the focus is on Latin America, and we'll go into that discussion in particular. But the concept of that's going on right now and has been happening in the last few years with respect to kind of revisiting investment treaty arbitration and investor state arbitration isn't limited to Latin America. It has been something that's occurred kind of globally, which is evident by different proposed changes to the system that have been going on for the last few years. Of course, the EU is rethinking investor state arbitration, and also in ICSID is recently, just on January 20th, submitted its proposed amended rules to the Administrative Council for a vote. And according to ICSID, the proposed amendments that it's discussing or including in those rules are the most wide-ranging in ICSID's 55-year history. They reflect extensive dialogue with ICSID's membership and the public, and the revisions focus on a number of different areas, including increasing transparency and the conduct and outcome of arbitration proceedings, new disclosure requirements for third-party funding, and expedited arbitration rules for parties wishing to shorten the procedural calendar. UNCITRAL Working Group 3 is also reviewing ISDS and to see what changes might be made to improve the system from, in particular, states' perspective. And in the next session, which is going to happen in February, scheduled to happen in February later this month, topics include considering creation of a multilateral advisory center, a multilateral mechanism for selecting and appointing ISDS tribunal members and related matters, and drafting a code of conduct for adjudicators in international investment disputes. So just indicating that what's going on or what has gone on relatively recent in Latin America isn't necessarily only happening there, but focusing on what has happened in Latin America recently. And in particular, starting with the ICSID Convention, because acts of Bolivia, Venezuela, and Ecuador, which is a unique case, are acts that have happened very recently and have implications with respect to the treaties involved there. So with respect to the ICSID Convention, Bolivia, who had signed on to the ICSID Convention in 1991, and it became effective in 1995. So not terribly long thereafter, in 2007, Bolivia notified ICSID that it was denouncing the ICSID Convention. In accordance with Article 71 of the ICSID Convention, then that denunciation took effect 6 months thereafter, as of November 3rd, 2007. Venezuela, shortly thereafter, also denounced the ICSID Convention. And I'm kind of skipping Ecuador because Ecuador came next in line in time, but Ecuador is a unique situation. So Venezuela had signed the ICSID Convention in 1993 and it entered into force in 1995. And in 2012, in January of 2012, Venezuela notified ICSID that it was denouncing the ICSID Convention. In accordance with Article 71 of the ICSID Convention, that denunciation took effect 6 months later, on July 25th, 2012. So it is something that one could argue is kind of a trend that was going on for a period of time in Latin America. And Ecuador is an interesting example of a situation where it denounced it, but then has recently changed. It has recently gone back. So Ecuador signed the ICSID Convention in 1986 initially, and it was ratified and entered into force in 1986. And in July of 2009, Ecuador notified ICSID that it was denouncing the ICSID Convention. In accordance with Article 71 of the ICSID Convention, that denunciation took effect 6 months later on January 7th, 2010. Very recently, the government, the decision by Ecuador to denounce the ICSID Convention is something that a new, relatively new government had reconsidered and decided under new leadership that they wanted to again sign the ICSID Convention, which they have done. And on June 21st of last year, 2021, Ecuador signed the ICSID Convention again and deposited its ratification on August 4th of 2021, and the convention entered into force on September 3rd, 2021. So it shows that there is certainly action that has happened in Latin America. Whether it's a trend or not is, I think, it really depends upon the nature of the government, and each government individually, for each country individually, to decide for itself what it wants to do, whether it wants to stay in the ICSID Convention or not. And obviously it's something that even if they decide to leave to denounce the ICSID Convention, they can, of course, re-sign, as Ecuador is an example of that. What is the impact of the withdrawal of the ICSID Convention for investors? Well, if you look at the key is to look at the applicable treaty or investment law authorizing the investor-state dispute settlement. If a provision that allows for an investor to go to arbitration includes other rules that they can use, such as UNCITRAL or additional facility rules, then those other rules are potentially an option for them to use. If only ICSID Convention is the only option for resolving disputes, then that takes care of that option. And if they denounce the ICSID Convention, then that is no longer a viable option for them to pursue. And then there's also a question that has come up with respect to what happens if an investor wants to bring a case in that period of time from denunciation until effective denunciation, which is a 6-month period. There have been certainly 2 cases in Venezuela that have indicated that as long as the request for arbitration, which is giving the consent on the part of the investor, has been filed within the period before it actually takes effect, the denunciation takes effect, then that would be sufficient for the investor to have given its consent. And that was the Clim Holdings versus Venezuela case, and the Blue Bank versus Venezuela case. The majority held that. That's one component of it. Another component of actions that have taken with respect to ISDS in Latin America on the same kind of topic is unilateral termination of bilateral investment treaties. So in addition to denouncing the ICSID Convention, some states have, including Ecuador, have also unilaterally terminated bilateral investment treaties. In particular, Ecuador terminated like 9 in 2008, Cuba with Cuba, El Salvador, Guatemala, Honduras, Nicaragua, Paraguay, and the Dominican Republic, Romania, and Uruguay. They terminated some more in 2010 and 2011, Finland, the UK, Germany, Sweden, and France, and additional ones in 2017, China, Chile, Venezuela, the Netherlands, Switzerland, Canada, Argentina, the United States, Spain, Peru, Bolivia, and Italy. The question is, why have these trends happened, or what has been kind of the purpose with respect to bilateral investment treaties termination? What have states said? Often it's the state, or perhaps the people within the state, have indicated to the politicians that they don't believe that on balance and they've gotten the benefit of the treaties and therefore believe that they should pull out of those treaties. Sometimes it could be because states want to renegotiate the treaties. Certainly there's been an evolution of understanding of what the terms of the treaties mean. Many of the early bilateral investment treaties are relatively thin on being descriptive as to what the meaning of a particular provision might mean, and therefore states want to renegotiate those. And so they have a better understanding now that there is a substantial body of case law to be able to understand exactly what they want to negotiate. So there are various reasons why a government might pull out. And again, in a lot of instances, this is not irreversible. It's something that they can reconsider and reverse later on if the balance is seen to be favorable to do so. From a practical perspective, what is the impact of termination of bilateral investment treaties? Again, other avenues might be available. They're not necessarily through that particular treaty. You could look to non-terminated free trade agreements or treaties. You could look to investment law, domestic investment law, that might also grant an investor the right to bring a claim against the state. Also, there are survival clauses that exist in some treaties. So the key would be to look, of course, at the language of the treaty to determine what the scope of that survival clause is. And survival clauses essentially are ways in which the government is providing protection to foreign investors who have made their investments prior to the date of termination. So if they've already made their investments in the government in the country, then and there's a termination of the treaty, often there'll be clauses that say that you can, if you are already invested at that moment when the termination took effect, then the investor has the ability for a certain period of time articulated in the treaty to still bring claims against the state. And an example of one of those is to use a 2019 Dutch model that's a survival clause, which says in respective investments made before the date of the termination of the present agreement, this agreement shall continue to be in effect for a further period of 15 years from that date. So, for example, if the BIT is terminated with effect as of June 1, 2017, in view of a 15-year survival clause, investments made prior to June 1, 2017 would remain protected by the BIT and for 15 years thereafter. The important thing in that situation, of course, is to look at the language of the BIT to find out what the exact terms of the survival clause might be. So in any case, I mean, clearly there are implications to investors with respect to what might happen if a government either denounces the ICSID Convention or unilaterally terminates a bilateral investment treaty. That can, of course, have limiting effect on investors. But there are certain things that are potential workarounds. And I think other speakers today will talk a little bit more about those other options. But in any case, I'm just giving you kind of a description of the lay of land of things that have happened in recent years. Again, I'm not sure it's necessarily a trend. I think it is something that each state determines for itself what is appropriate at any moment in time. And again, looking at Ecuador, it is also something that can be changed over time. You can decide that it's in favor of the state to enter into the ICSID Convention and change that later, and also can go back in. So there are a lot of things that states can and have done to reflect the interest of the population of that particular state when they look at the balances of what they think is useful in order to attract investors or to renegotiate the terms of those bilateral investment treaties. But in any case, I think I'll stop there so we can let the others give their presentations momentarily.
Thank you very much, Ms. Haworth McCandless. Now we will hear any comment that Mr. Taylor or Mr. Aguirre may have regarding this topic, and if they don't have any comments, then we can move forward to the next presentation. Mr. Taylor, Mr. Aguirre?
Roberto, do you want to go first?
Well, yeah, I'm fine. Thank you, Patrick. The only comment I wanted to make is that I think that the moment you see what Ecuador did comparing to Venezuela and Bolivia, they pulled out of ICSID, but at the same time, they put an end to the international arbitration system. At least Venezuela and Bolivia, I think, was the most radical when they decided to eliminate all the international arbitration clauses in their contract, especially YPF-B, which is the main company, at least the one that receives most foreign direct investment. So that was a big issue for those advising multinationals or international oil companies, because it certainly limit the number of companies that were willing to continue operating in Bolivia. So it was the decision to pull out of ICSID, to denounce bilateral investment treaties, to only accept arbitration with the seat in La Paz, and to renegotiate all the oil companies. So it was a full package that very few companies were willing to eat or to take. Ecuador went a different way, because while they did pretty much the same ideological move, which is pull out of ICSID, denounce bilateral investments, some bilateral investment continue, not all. And then their renegotiation of the oil contracts was subject to arbitration seated in Chile under Ecuadorian law, with the PCA, UNCITRAL, or sometimes the Chamber of Commerce in Santiago as the seat of arbitration, which allowed a larger number of companies that were willing to take that risk. And then Venezuela did something similar. You have a few agreements of the mixed companies that provide international arbitration, but most of them provide for domestic arbitration. I think that at least from the operating perspective, advising foreign investors, it made a difference. Although some foreign investors continue operating in Bolivia even today. So I just wanted to add that color to the very good presentation by Jennifer. Patrick, I don't know where you
Thank you, Roberto. I was just going to make a point from the European perspective, which is, I think if you're advising investors and you're facing denouncements of ICSID and withdrawals from bilateral investment treaties, there are still plenty of options. And I think what we've learned from the European events is that the states need to go to very great lengths in order to free themselves completely and immediately of all obligations under bilateral investment treaties and the ability of investors to commence arbitration. In Europe, it's required multilateral treaties between all the parties to the intra-EU BITs, denouncing all of those BITs at the same time, including the sunset clauses that Jennifer was referring to. And even then, it's been quite difficult for the states to resist ICSID arbitration in many instances. So my message would simply be that if you're facing this situation, there are usually options, but it's important to advise your clients, of course, of the risks, especially the risks that will arise at the point of enforcing any award that you might ultimately get.
Thanks to all. Well, now moving on to the second topic, Mr. Taylor will address the issue of UNCITRAL arbitration as an alternative to ICSID arbitration.
Well, thank you very much, Gino. It's a pleasure to be here, notwithstanding the late hour in London. I'm delighted to have been invited, and thank you very much for the opportunity. So, as Jennifer said, the first step, if you're facing the denouncement of ICSID, is to analyze the solutions that are provided for you by the dispute resolution provisions in the applicable instrument that you are protected by. And there are broadly speaking, three different approaches that are taken by South American bilateral investment treaties. And you'll need to consider which one you fall under. And hopefully you'll fall under one that gives you an option to access UNCITRAL or another form of arbitration. But today I'm going to look at comparing specifically UNCITRAL and ICSID. But first, the three different types of structure that you might have in your dispute resolution, and this is on slide 2, is first, if you could turn to the next slide, that would be terrific. Thank you very much. So first, it's sort of alternative electable options, such as you have in the Argentina UK BIT, where the investor is actually allowed to choose whether it wishes to bring ICSID or UNCITRAL arbitration. A slightly different model is what I've referred to as the alternative prioritized options, such as the Venezuela-Spain BIT, which has been written about quite a lot recently, given some recent decisions, where the investor can bring ICSID arbitration or ICSID additional facility, but if ICSID is not available, then the investor is allowed to bring a claim under the UNCITRAL rules. And then the third type, which if you had, you would hope it's provided for UNCITRAL rather than ICSID, would be the sole prescribed option, such as the Argentina-Vietnam BIT, where UNCITRAL is the only option available. So if you've got a choice, you'll need to think about how the alternatives that are available to you differ and which is better suited to the specific circumstances that you are in your particular case. So we can turn to the next slide. Looking then specifically at a comparison of the ICSID system and the UNCITRAL system, the first thing to say is that they are fundamentally different. ICSID offers a self-contained system under the 1965 Washington Convention, which is the ICSID Convention, and it offers essentially supranational arbitration with no national seat, no place of arbitration. UNCITRAL arbitration, on the other hand, is like, if you're familiar with commercial arbitration, is much more like a commercial arbitration. It's grounded in the national procedural laws of a chosen or determined national seat of arbitration. And that fundamentally different character of ICSID arbitration impacts the access to ICSID jurisdiction, a number of features of ICSID procedure, and the enforcement of an ICSID award. And I'm going to look at those each briefly with you this evening. So turning to the next slide, if we could, and first to the question of jurisdiction and admissibility. In general, investment treaties will grant protections to, quote, investments by a, quote, investor of one contracting state in the territory of the other contracting state. Some argue that a qualifying investment in an ICSID arbitration is or could be different to a qualifying investment in an UNCITRAL arbitration. In both regimes, you're going to need to satisfy undoubtedly the definition of investment as set out in the investment treaty that you're claiming under. But and in most of those BITs, the investment will be defined quite broadly, and it will cover most economic activities, including shares. But when the claim's brought before an ICSID tribunal, the test for what is an investment will also be impacted by Article 25.1 of the ICSID Convention. And it's been argued that the reference to investment in Article 25.1 is an autonomous concept, separate from the definition of the investment that you might find in the treaty. Now, usually when advancing that argument, states will say that in addition to meeting the definition of investment set out in the treaty, you're going to have to also show that your investment has the intrinsic qualities referred to as the Salini criteria. Now, those criteria require that investment should involve a contribution of money or assets over a certain duration of time, containing an element of risk for the investor, and making a contribution to the host state's economy. The argument is that investment protections are there to attract foreign direct investment to benefit the host state, and that the protections reward an investor that's willing to take the risk of investing in that state. And so while building a toll road in a Latin American jurisdiction with an investment treaty ought to constitute an investment, buying a metro ticket in that state would not. And the argument relating to the necessary intrinsic qualities doesn't arise in the UNCITRAL arbitration context unless your specific bilateral investment treaty sets out those criteria expressly. So it has been argued that it's arguably easier to access the jurisdiction of your UNCITRAL tribunal if you have an investment that might be in the grey zone between what's generally considered to be an investment and something which clearly is not an investment. So turning then to the next slide. Which investors are protected can also differ between an ICSID arbitration and an UNCITRAL arbitration. Again, in both cases, the claimant is going to have to satisfy the definition of an investor included in the investment treaty. But Article 25.2 of the ICSID Convention limits arbitral jurisdiction to disputes between a contracting state and a, quote, national of another contracting state. And that's been interpreted to mean that natural persons who are nationals of both the host state and the other state are barred by the ICSID Convention from bringing claims against the host state. UNCITRAL tribunals have historically been more permissive with respect to allowing claims by dual nationals. But it is a complex area, and as I think the Manuel García Armas and Serafín García Armas cases against Venezuela demonstrate, it can be fraught with difficulty. Now, the Spain Venezuela BIT is really the cause of that complexity in the case. I referred to this BIT earlier and mentioned that in that case, you were only allowed to access UNCITRAL arbitration in the event that ICSID arbitration is no longer available to you. And in the Manuel García Armas and Venezuela case, the tribunal noted that the dispute resolution provisions in Article 11 established what it referred to as a certain hierarchy between the different options to arbitrate, and then it conferred primary jurisdiction on the ICSID system. As a result of that, the tribunal reasoned that the UNCITRAL jurisdiction was a secondary jurisdiction which was not designed to create a forum with a broader or different jurisdiction than the primary option. So it was therefore concerned to make sure that the claimants were not dual nationals. By contrast, if we go to the next slide, the opposite conclusion was reached in the Serafín García Armas and Venezuela case. In that case, it was found that in the UNCITRAL context, the BIT did not prohibit claims by dual nationals against one of their home states. Most recently of all, 3 days ago, the Fernando Fraiz Trapote in Venezuela case was reported. And in that award, the tribunal declined jurisdiction of the claim by finding that the investor's dominant and effective nationality was Venezuelan. And according to the tribunal there, international law does not allow dual nationals to sue their own state in an unrestricted manner. So it can be noted from these cases that even in the UNCITRAL context, dual nationality can be an issue. If we go to the next slide, please. So concerning the formation of the arbitral tribunal, I'm going to keep my comments very brief in the interest of time. Under Article 39 of the ICSID Convention, there are some restrictions on the nationality of your tribunal members, whereas under the UNCITRAL rules, there are no specific restrictions in the rules, although there could be in the particular treaty that you're bringing your claim under, or in the national law of the seat of arbitration, and you should be mindful of those. As for the appointment of members of the tribunal, the processes between ICSID and UNCITRAL do again differ. Mainly in the ICSID context, the appointment is heavily impacted by the actions of the ICSID Administrative Council, whereas in the UNCITRAL context, you'll have reference to an appointing authority that will do the appointments in the event that there's no agreement between the parties. If we go to the next slide. Really, I think that the main takeaway on that is, in my experience, the appointment processes under the ICSID rules tend to be slower than under the UNCITRAL rules, and it's yet to be seen whether any of the revisions to the ICSID rules, if they're passed, will assist there. But that can be very important if you need provisional measures. If you're advising a client that needs provisional measures urgently, then being able to get your tribunal set up quickly could be very important. In those circumstances, the UNCITRAL system may be preferable. On challenges to arbitrators, again, there are some slight differences as to, in the ICSID system, it's the non-challenge members of the tribunal that decide first, whereas under the UNCITRAL rules, it's the appointing authority. So if we go to the next slide, please. So I'm going to turn finally to the award and the enforcement of the award. And actually, this is the area where perhaps some of the most interesting distinctions exist, and perhaps the most important ones as well. As I mentioned earlier, ICSID has no national seat, whereas the UNCITRAL arbitration will be seated in a specific national jurisdiction and therefore subject to the supervision of the local courts, including when it comes to questions of enforcement. For challenging an ICSID award, under the convention, annulment is considered to be an exceptional recourse, and it's designed to safeguard against the violation of fundamental legal principles relating to the process. The application for annulment will be made to the chairman of the Administrative Council, and that person will appoint a 3-member panel of arbitrators to form an ad hoc committee, which will decide the application on the basis of the ICSID Convention. They'll also decide whether or not to grant a stay of enforcement. The ICSID rules don't have any provisions on challenges to awards. Instead, that issue, as I said, will be determined by a national court. If we go to the next slide. When it comes to recognition and enforcement, the ICSID Convention, Article 54, states that there's a general obligation according to which all contracting states to the ICSID Convention have to enforce the pecuniary obligations imposed by an ICSID award as if they were final judgments of their domestic courts. Now, that's very helpful. In practice, that means that an ICSID award can usually be enforced without challenge in all countries that have ratified the ICSID Convention, unless the annulment proceedings were successful. UNCITRAL awards are generally enforced under the New York Convention, and that will be applied by the domestic court, which will also consider whether or not any of the exceptions to enforcement provided for by the New York Convention will be applicable, and therefore it tends to be considered a slightly more difficult route for the enforcement of an award than the Washington Convention. So I hope that this has shown that if ICSID arbitration is not available to you, then UNCITRAL arbitration will often be a perfectly good alternative. Indeed, perhaps sometimes a preferable alternative. It all depends on the circumstances. But I'm going to leave again with one final European perspective. In the European context, because of the Achmea decision that has ruled that arbitration under all intra-EU BITs is contrary to EU law, UNCITRAL arbitration is not going to be the favoured choice. Because the UNCITRAL arbitration is going to be seated in a national jurisdiction and usually in a European jurisdiction, the European Court considering a challenge of that award under the current rules and laws in the European Union would have to, and indeed many courts have decided, that the awards are contrary to EU law and therefore have set aside those awards. The ICSID system, because it's hermetically sealed and supranational, isn't subject to that same national oversight, and therefore most cases proceeding under intra-EU BITs at the moment do so under the ICSID system. And in the event that anything similar to what's going on in Europe should happen in Latin America, that would certainly put a different lens on how you would approach your choice between different rules.
Thank you very much, Mr. Taylor. This was a really interesting presentation and a dynamic one. Now let's see if Ms. Haworth McCandless or Mr. Aguirre Luzi have any comments on your presentation.
Roberto, do you want to go first?
Yeah, sure. My main comment is that over the years, especially 10, 15 years ago, there was an idea that having an ICSID award will allow you to get a better chances of collection of payment because it's treated as Patrick very well explained, a judgment of the highest court where you're enforcing. However, over the years, I think that that idea that World Bank will, ICSID seal and the ICSID Convention, all of that will allow you to get better chances or likelihood of collection of payment over an UNCITRAL or over a New York Convention, let's put it, a war, in my experience, has proven to be not that, not exactly as theoretically possible. And the reason is that sovereign immunity is still a very important defense when trying to enforce a credit against a sovereign in a foreign court, regardless of that credit being an ICSID convention or not, because the moment you turn that into a judgment, so the moment you turn the ICSID award into a judgment of the highest court in let's say, the District of Columbia or Madrid or, in other jurisdiction, you still at the end, if you don't get voluntary payment, you still need to find assets. And those assets are going to be protected by the sovereign immunity, which is for some specific countries, including those of my own nationality, tend to be a rather complicated obstacle. So that was a perception back in early 2000 that ICSID will, having an ICSID award will put you in a better position to collect. And I don't think it's there when the debtor is a quite sophisticated country that know how to hide assets. And this situation of Argentina thinks applies to Venezuela and could apply to European countries that have been subject of a number of claims that are still fighting. So it's a tool that is not left only for recalcitrant debtors, but also for those that are trying to fight the long fight. Only that comment. Very good job, Patrick. Very interesting.
Yeah, that very interesting comment too, Roberto. And I guess I think there's a trade-off. I mean, I think based on what Patrick put forward, it's clear that there are pluses and minuses for each. And my only note was that you were drawing a distinction with respect to the Salini test standards, kind of which is traditionally or often been used in the context of ICSID. But I have also seen situations in which it's been applied in where UNCITRAL rules apply. So it may be a case where that distinction is starting to narrow. So it may be over the course of time that these differences that could be more stark, at least on paper, if you take that comment in conjunction with Roberto's comment, it may be that the differences can narrow over time, or maybe have narrowed a bit over time. So they're not quite as stark as perhaps they had been in the past.
Thanks to all. I just want to say to everyone to feel free to make your questions in the YouTube chat box. The speakers will address them at the end. And finally, we reach our third topic. Mr. Aguirre Luzi will address treaty shopping. Mr. Aguirre, the audience is yours.
Thank you, Gino. I wanted to thank the Columbia International Arbitration Association, Laura and you for the invitation. It's a pleasure to share this panel with Jennifer and Patrick. And the topic that I have is treaty shopping, that kind of fits well with the prior two topics because it's kind of a consequence of the same topics that have been addressed before me. And the first point I wanted to make is that I don't like the treaty shopping war, the way that it has been named. I think it has a negative connotation that is not free, because I rather use the word treaty planning or restructuring. The reason is that there is nothing that at international law, public international law, that prohibits or bans investors from trying to find the best treatment through incorporating or structuring their investment to the best jurisdictions. The same way they do it from a tax perspective, or from other type of perspective like sanctions or things that are less common but still frequent when you're advising multinationals in particular. So having said that, is we need to understand that treaty planning is part of doing business, trying to find the most favorable environment for your structure for your investment. That is something that is reasonable because investors are trying to be efficient and effective in doing business and getting the best treatment possible for the investor and their international law and their free trade agreements or bilateral investment treaties is something reasonable and lawful. If sovereigns or states want to limit the way treaty planning is done, they have all the power to do so when they negotiate the treaties. And you can see over the last 30 years how treaties have evolved and show the experience of different countries and provide a specific language that makes it either harder or very difficult to allow investors that are not nationals of the two parties or multilateral treaties of the parties in the multilateral treaties to channel their investment under the nationality of a company protected by those treaties. So there has been a lot of evolution over the last years in Latin America too. You have treaties in Chile that have narrowed down the protections and have made it more difficult to find a way to invest. And the same can be said with the free trade agreements negotiated by the US and Canada. You can see that they have learned over the years the limitations that you can include in the definition of investors, in the clause of denial of benefit that I'm going to talk now. So my general point is, again, don't use a negative term like treaty shopping, because then you're insinuating that you have a position on the starting point. And second, understand that this is reasonable and lawful conduct for investors. So having said that, is the main issue that you have when I'm trying to advise an investor on how to protect their investment is first timing. How close are you from what could be an adverse act against the investor, against the investment? if you are in a situation of being at the beginning, at the inception of the investment, is different than when you are with a storm coming and seeing. That's critical from the perspective that a tribunal will eventually see these elements and when deciding whether they have jurisdiction or not. The second point is, what exactly is your client? Is this going to be an investor, individual, physical person, or is going to be a juridical person, company? Those are also critical points that need to be, as we will see, considered early on when you decide this. And of course, then you have the cases that involve an investment that has already been made and that is about to be impacted by a measure from the government. That's another scenario that I will try to explain. So why is treaty shopping very controversial institution? And I think the reason is because states tend to reserve the rights as to how to deal with investors in arbitrations early on. So they have the tools, and even the early bilateral investment treaties provide states with the tools to allow the state to limit the type of investors that are willing to cover and protect. The problem happens when you have situations that go outside the specific terms of the treaty. So when the lex specialis is not clear, or it allows for interpretations, is when you have the problems. The second situation is when you create mega disputes, like it happened in Venezuela or in Bolivia too, in Argentina, where you create a number of type of disputes that are extremely difficult to foresee when you are negotiating a treaty. And for that, I'm talking about massive nationalizations or massive amount of changes in the regulatory framework that affect not just foreign investors, but nationals. So then you put the system to a test. And that's where you see for example, the decisions that have been mentioned by Patrick involving Venezuela, involving nationals that have dual nationality or that have tried to structure the investment through a company in a third country that has bilateral investment treaties. Because it's at that point where you are running out of options as to time. So being more specific, all type of planning, restructuring planning, is usually allowed. It's not prohibited. So that is critical to understand why, when you are discussing with a client, for example, a natural person, you need to understand that you are not doing anything wrong. What you're trying to do is just trying to find a way to allow protection of that investor. Natural persons are perhaps the most complicated of all the situations. Why? Because the issue of nationality is a pretty controversial issue, even in public international law and the diplomatic protection that has over than not 100 years, but probably 100 years of discussion in diplomatic protections cases that are extremely controversial over the years. So the moment you start talking about individuals and dual nationals and nationals that are trying to get a second citizenship to allow them protection, you get in what is perhaps the most difficult battleground for investment. So that is usually the case when they have run out of time and they have no means of preventing this in the foreseeable future. I'm going to have a dispute. I'm going to structure my investment to companies outside the country. There are many treaties in the region that still today allow you to do that and allow you to do that in a lawful way. So individuals are the most difficult investors to protect, even when a dispute has not yet arisen. Corporations are, even today, the most common type of beneficiaries of these techniques of restructuring the corporations change to allow them protection in different investment. Pretty much all the treaties allow you to do that. The problem is restrictions on what I would call the definition of investor, the definition of the legal entity that you're trying to incorporate in the jurisdiction. Treaties have usually allowed a definition that, at least the early ones, that the nationality of the company is managed by, for example, the place of incorporation, the seat of the company. But over the years, they have tried to limit or make it harder by adding different type of restriction, for example, substantial activity in the place of incorporation, that adds a more difficult test that can be complied with, because substantial business activity can be complied in different ways, but allows a more careful planning. Then there have been also restrictions as to the final control of those entities. And that's what, for example, one of the cases with the denial of benefit clause, that is a clause that has been around for many years. Even in the first or second model of the US bilateral investment treaty, you have a denial of benefit clause. But the denial of benefit clause is a clause that allows the state to deny individually the benefits of a treaty to specific investors when, for example, they are controlled by a third party with which that state doesn't have relationships, or because they don't have substantial business activity in the country, and they have decided not to allow those type of investors to receive the protection of the treaties that have been negotiated. The critical point of denial of benefits is, when does it apply? Unlike the definition of investor, that it applies from the moment the treaty has been implemented, has been ratified, the denial of benefit clause usually applies when the state denies individually the benefits to an investor. That should happen perhaps when the investment is made, rather than when the dispute arises. But there is discussion, and there are cases that discuss the timing of the denial of benefits. But that's another of the issues that Council needs to take into consideration when advising a client in restructuring their corporate structure to get the benefits of of bilateral investment treaties. The third point that usually creates the most difficult issues is when you do all of these, when, as mentioned before, the storm is already in the horizon. There is a number of cases that have discussed when is it reasonable for you to restructure your companies in order to get protection in a country that is about to change the regulatory framework, is about to affect your investment. There are some cases that have decided that as long as you do it before the dispute arises, you are okay. But there are other cases that have said, if it is a foreseeable that the dispute may arise, then it's too late. Even though the dispute has not arisen, if you foresee that the dispute may arise, it is too late for you to do it. And they invoke the principle of good faith, saying that it's not going to be in good faith for you to restructure the investment when it's foreseeable the dispute will arise. This usually is not in the text of the treaty, but it's in what we call implicit limitations or restrictions in treaties that come from interpretation under international law and the principle of good faith that comes with the Vienna Convention. So that is another very controversial issue that brings that gives result to a number of awards that have provided different results to very similar situations. The next point is the transfer of claims, which is related also to treaty play. And Gino, Elora, please let me know when my time is up. I'm good. The next point is transfer of claims. So what happens if you transfer your rights under the treaty claim and in order to improve your standing, your situation, jurisdictional situation under a treaty? That's another very controversial and more difficult issue that involves the same issue of ratione temporis, ratione persona. You gotta comply with the text of the treaty, but on top of that, you have implicit limitations that I mentioned, like, for example, applying, interpreting the text of the treaty in good faith. To that, you add another layer of argument, which is the abuse of right. The doctrine of abuse of right is one of the usual arguments that you see being brought up by states in order to criticize or object to the investor's decision to restructure the investment in order to get protections. And this is not an institution that is provided in the treaty, but it's provided and recognized in international law, in public international law. And it's usually the way tribunals have, at least some tribunals have managed to dismiss claims with the argument that they are abusing the system by trying to circumvent the limitations on the definition of investor, or in the case if you're adding ICSID Convention to the, as Patrick explained, you're bringing a treaty claim under the ICSID Convention and you have a dual national. The most common defense has been the abuse of the procedure, because you're going against the goal of one of the objects of the ICSID Convention, which is to protect investment done by an investor from a different country than the host state. So that is a doctrine that is being debated. And in my view, one of the main issues that you gotta balance the invocation of abuse of right is what type of investor is and what type of dispute is, in order to understand whether that investor was in a situation that has been forced by the same measure that are being invoked, has to be weighed in. And what I'm trying to say is that if you have investors that have been that have seen their assets completely nationalized, completely wiped out by states, that then are trying to invoke the confiscated more than nationality, and then they're trying to invoke doctrines of abuse of rights or good faith in order to preclude their liability and international law, that needs to be balanced. It needs to be taken into consideration, the whole analysis. Because at the end, the state has been enjoying that investment and has been acting also in bad faith by confiscating it. Of course, it's controversial if you do this after the fact, after the dispute has arose. But if you have done this early on, or at least with enough anticipation, these type of factors need to be taken into consideration. Because in many of these options, in many of these cases, that investor is left without options. And the only option that they had left was the treaty option that is going to be taken by the state that has nationalized, confiscated the asset as an abusive process when the unlawful conduct is uncontroversial and has caused a harm that needs to be addressed by the tribunals. So it is correct that there are many awards in Latin America that have addressed this issue over the last 15 years. And I think there is a number of these awards that are prompt to discussion and controversy. For example, the one mentioned by Armas, by Patrick, the Armas cases, the one that came out last week. They're extreme examples that are subject to controversy, and we haven't seen the end of this type of saga of cases, because in what I expect expect this region to be is that it's a cycle of type of dispute and measure. So we will see more of these cases coming, in particularly from countries in Latin America. So I don't see a trend, and I don't see an end of the debate on treaty shopping or treaty planning, but I do see a continuous evolution because of the way investors are acting, protecting their investment the best way possible, and sovereign states changing the policy in accordance with the government in turn. And with that, I'm trying to close, Gino and Elora, and in your hands.
Thanks a lot, Mr. Aguirre. Well, Ms. Haworth, Mr. Taylor, feel free to issue any comment on this.
Patrick, do you wish to say something first?
No, it was an excellent summary of everything, and I may have offered a couple of practical perspectives, but in the interest of time, I think, Roberto, you covered everything. Thank you.
I guess I'll just say that I like your attempt, Roberto, to change the topic or the title, I guess, of the subject to say not so much treaty shopping, but restructuring, which I think is, for the most part, in most cases, that's the situation. And it certainly is advisable for those who are looking to make investments internationally, to look at the lay of the land, see what the requirements are under the treaties. If there's, it is legitimate, as you say, if it's done sufficiently in advance, and clearly, if one is just making the investment into the country, that's the time in which advisably you would look at the available treaties and see what makes sense from a structuring standpoint to where you would want to structure how you would want to structure the investment, so you can take advantage of the treaties. There is nothing wrong with that in and of itself. It is, as you were identifying, there certain situations if you're in the middle of or foreseeable dispute, that there are limits to what you can do. So I think the advice is to look when you're doing the initial investment and determine the structure at that point in time where you don't have the controversies that could potentially exist down the road if you wait until a dispute arises, or even it's foreseeable. So it makes sense to look at the lay of land and decide what is this, how to best structure to get the best protections provided within the bounds of the treaties. So each treaty is going to identify what its limitations are. And so that's important to take those into consideration as a practical matter before making investments. Better to do it up front than to wait.
The earlier the better.
Thank you, everyone. I think now we can move to the questions. We have some questions on the chat, and Gina and I, of course, have a few questions as well. I think I'm going to start from bottom to top. First of all, congratulations for the speakers, and once again, amazing presentation, very enlightening and linear. I think it was the best way for everyone to understand what are these current issues. I think Roberto already sort of answered the question put by Gustavo, which is a fellow LLM of ours, in the meaning of, do you think that LATAM's denunciation trend will restructuring have a bigger role as an option for investors? So maybe Patrick and Jennifer can follow up on that and give some of their thoughts on this issue.
Yeah, I mean, I think it's very probable. I think that, again, if in making an investment in a country, the investor needs to look at how to structure that investment. And I, again, push for doing that early rather than later. And you look at what is the lay of the land at the moment in which you're making that investment. You look to the treaties that are in force or not in force, and you do act accordingly in order to take advantage to the extent that you can. I mean, as it's rare that an investor is going to make a decision on structuring purely on the basis of treaty protections. Usually it's the most important day-to-day issue is taxes. But to the extent that investors are looking holistically, then they need to take into consideration what protections exist at the moment in which they're making the decision to invest and act accordingly. Yeah.
And as Jennifer says, I mean, taxes is a much easier sell for clients because there's an immediate financial impact. It's much harder when you're speaking to clients to persuade them of the value in undertaking something that might be relatively onerous, especially if they've already made the investment and they've already got a particular structure. Changing that structure can actually have real costs, including tax costs associated with it. And persuading them that they should do that because of a storm that you see coming down the road when it's not yet crystallized is quite difficult. But once it has crystallized, they may wish they had done it, but by then it's often too late. And so all you can do is take the horse to water, but you can't force them to drink.
Perfect. I agree. The next question, well, the first question is another fellow of ours, Camila. She asked, how do speakers see the political and economic changes that Latin America countries underwent with the pandemic affecting the investment arbitration scenario? Maybe now Roberto can take on that.
Yeah, absolutely. I mean, we had Gino here, they're from Peru. In Peru, there was a COVID, for some time, a COVID type of statute that allowed the state to say, don't charge for, I think, toll rates. There have been cases related to force majeure, I think more commercial cases and treaty cases all over the place. And actually they're winding down some of them because it's become by now the norm, the COVID. But what I do see is in some countries in Latin America or even in the Americas, where the powers, emergency powers that were granted for COVID, they may remain. And if those powers are abused, then there could be chances of seeing treaty cases. But I think COVID has provided more work on the commercial side than in the treaty arena, with a few exceptions. I don't know whether Jennifer or Patrick want to add, but I think that is at least what I have seen.
Jennifer or Patrick want to add on that?
I mean, only to say that COVID obviously has, depending on the nature of the government, these things are often cyclical in certain jurisdictions in Latin America, and Argentina is a good case in point, where at different times the governments have done different things that either have triggered more claims or fewer claims, and COVID can create circumstances that may lead to governments taking certain measures that would lead to more claims. But it's more, I think, the cyclicality of the nature of the governments and the policies necessarily than COVID itself.
Yeah, I will refrain from commenting since I'm involved in disputes concerning issues related to this topic.
Perfect. So next question, also from Camila. Do you think that commercial arbitration can play a significant role in the protection of foreign investors in Latin America if investment treaty arbitration is not available? And I want to add on that do you have any sense on whether states may follow the Brazilian tradition, which is the good old diplomatic exposal? Maybe Jennifer, if you want to take on that.
Well, I mean, I think that I'm not sure one would replace the other per se, because I think that they're of a slightly different nature. So commercial is two commercial parties. So to the extent there are two commercial parties, of course, taking advantage of commercial arbitration is a perfect option. To the extent that one party is the state acting, then the commercial arbitration environment is not going to be adequate. So it really does depend upon the nature of the dispute. If it's something which is kind of possible to be resolved through commercial means, then if that is the only avenue available, then that would of course work. But again, there's a distinction in the nature of the disputes, which may limit the ability to resolve everything purely through commercial arbitration proceedings.
And what about maybe, Roberto, if you can speak on diplomatic expulso, for instance, which is the Brazilian trend?
Well, I don't know, one case with Brazil, a country has exposed claims against Brazil. So that tells you that that's an archaic, mid-ages type of solution. I might be wrong, but I don't remember seeing Brazil in the ICJ defending a case. So, there is a reason why bilateral investment treaties or free trade, so, the whole investment arbitration system was imposed, and that is to actually avoid begging a country that has a number of public policies, ongoing with that other state to actually see the issues of one investor to then take that state to an international forum for that investor. I think that system doesn't work. It has a lot of limitations. It's very expensive for both states and investors. And that's the reason you have. I mean, might be wrong, but I don't remember seeing one case, recent case in the last 10, 20 years of diplomatic protection in Latin America, not just Brazil. I think Brazil just decided to go one way, and it's still being discussed whether to join the investment arbitration system or not. But they have managed to get foreign direct investment, without it.
I don't think we are.
Yeah, I don't think this is going to happen, but you have managed to get, because the resources are there, and at the end, the option of domestic and international arbitration for the major sources of foreign direct investment, or the major destination of foreign direct investment, to put it that way. Oil and gas it has both domestic and international arbitration. M&A has a lot of domestic arbitration, and courts have stand by the rule of law regarding have honor awards. All of that is very important, but you don't see that in every country in Latin America. So the question is, the trade-off that you have for not having investment treaty, but you have very strong arbitration system, and the court system also is not it's not that bad either. So those trade-offs are not the same in other jurisdictions.
Understand. My last question is something on, I want to follow up on something that Patrick says, that advising regarding, he was talking about Jennifer's presentation, and then when talking about advising clients, you mentioned that there's still plenty of options, and then you mentioned also something on risk of enforcing an award. Can you elaborate on that a little bit?
So it's one thing we're obviously living through unprecedented times in Europe in terms of the attack of the European Union on intra-EU arbitration, and everything is changing here very fast. And it's one thing to be able to advise clients that you can still access arbitration, you can still bring claims under your bilateral investment treaties. There are ways around what the European Union is seeking to do to make it more difficult to bring those claims. But ultimately, these claims only have value if you can enforce them. And if you decide that the enforcement is in a state, a bit like Roberto was describing, that increasingly it's become quite difficult, and states are less willing to comply voluntarily, and you have to deal with sovereign immunity and all those sorts of issues. It takes a long, long time, and it costs a lot of money to get to that final stage. And if you ultimately can't enforce, then that may be a good reason to think about the alternatives. And it's been interesting to watch Spain, for example, that in the face of all of the renewables claims and the Achmea decisions, has said that if you give up your claims, it will offer you a route to a resolution through the courts and alternative means of compensation. And some investors have taken that. They've evaluated the risk of going through a very lengthy and expensive process to get an award that may not be enforceable at the end of it. and the alternatives that have been put on the table by the state. So all I meant by that is you really do have to consider that final stage as well, not just whether or not you can get to a point where you have an award.
Perfect. Professor Berman.
Just want to add something on Patrick. Very good comment. Is sorry, now just to add on that, that it's very expensive for investor to follow that path when the state decides to make it harder for you to collect, but it's also very expensive for the state because making sure that a government is not vulnerable to seizure of assets is very expensive as well. It requires a lot of work with sophisticated lawyers in a number of jurisdictions that is a very expensive fight for both. Of course, not usually states have deeper pockets, they have more time. But it's a battle that is not good for anybody. Neither side gets a benefit other than, kicking the ball farther down the road.
Yes. I was going to say that, Patrick, Professor Berman spent a whole class in our investor state arbitration class last semester talking about Achmea and Mikula Brothers' decisions. So we're tuned on what's going to happen with those intra-EU BITs. Unless, Gino, do you have maybe a final question for our speakers?
Yes, I know that I'm not a speaker, but my country has been involved. So I just want to say that this statute that suspended the collection of the toll fees was really a headache in my country because Congress took this decision, even so that the executive branch warned them that this was going to be a really problematic issue. And now I understand that we are having like 6 cases related to this. So yes, well, I just feel that I just wanted to share this feeling with you. It's really problematic to the situation in Peru and its connection with investment arbitration is, for a Peruvian, is kind of a headache too. That's that. I have a final question for Ms. Haworth McCandless. So just a specific question regarding the cases of Venezuela. I just want to know if you consider that this 6 window period actually may be subject to debate, because there is one case, also a case related to Venezuela. This is Fábrica de Vidrios versus Venezuela, in which like the arbitral tribunal seems to actually adopt a different view as compared to the cases of Menocrim and Blue Bank.
Well, I guess it potentially, it's open, sure. Every tribunal is going to come at the issues before them and make their own assessment. It's, in those 2 cases, the logic seems fairly straightforward, which is to say there's a denunciation that is notified, but under the ICSID Convention, Article 71, it doesn't take effect until 6 months thereafter. The debate that they were resolving was, if you file your request for arbitration during that window, but it's not registered during that window, then what's that effect? Is the consent given at the moment of the filing of the request for arbitration, or is consent given once it's been registered? And the tribunals, in the majority in the Blue Bank and the tribunal in the other case, had said that it's when it's the investor files the request for arbitration, because that is the investor at that moment is giving its consent, and it has no control over the timing of when it's registered. If it goes to ICSID, it can't control that. And so that was the basis for that. I don't know the facts of the case that you're identifying as to whether there were different issues at issue there. So it depends upon what the facts are of the case, and each tribunal is independently going to, of course, make their own determinations. But in the 2 cases that I mentioned, they were looking very specifically at Article 71 of the ICSID Convention, which is indicating that the denunciation itself does not take effect until 6 months after the notification. So that in and of itself seems somewhat straightforward. that I think has been a novel issue for tribunals to interpret in the context of Venezuela, because up until that point, well, there are a very limited number of countries who have denounced the ICSID Convention. So that creates a new set of issues for tribunals to weigh in on. So I wouldn't be surprised if there are some inconsistency, but I mean, usually that is based on factual issues.
Thank you very much, Ms. Haworth McCandless. Well, I don't know if maybe any of the speakers have any final comment to say. If that's the case, you feel free to do that.
Thank you, Gino, Elora. Thank you, Jennifer and Patrick, and the Arbitration channel for making this possible. I really have fun. I enjoy listening to all of you, and look forward to the next event.
Agreed. Yes, I second that, and thank you for Colombia International Arbitration Association for putting this on, and for Gino and Alana for providing this, and yeah, Patrick and Roberto, good to see you, and good, very interesting comments. I've enjoyed it.
Likewise, and thank you for letting me crash from across the other side of the Atlantic.
Thank you all for joining us and giving such a great presentation and being patient with our questions and everything.
Pleasure.
An honor
Yes,
to be here.
Thank you very much, and also thanks to everyone for being here, to the viewers. And well, this was a really insightful discussion. I just have to say bye. Thanks. See ya.
Thank you. Bye.
Till next time.